Okay, welcome. We got question 3 from 2015 July. It's a criminal procedure essay dealing with only the Fourth Amendment. And the whole topic on this, oddly enough, is what is a search? It has so much to do with what a search is. And the reason why, this essay is July 2015. In 2013, the Supreme Court came down with Florida versus Jardines and defined what a search was by two things, whether it was a trespass or whether it was a reasonable expectation of privacy. The trespass doctrine actually goes back about 40 years. The Supreme Court has kind of returned to it. So that's what this essay is about, and it deals with search under the Fourth Amendment. Okay, let's go to the call to the question. It said, how should the court rule on each point? With criminal procedure, it'll say how should the court usually rule on each motion. Here it says each point. That's your clue to go up to the paragraph right before it, almost always, and it'll tell you what the call to the question actually is. So the call to the question starts with, Dora has moved to suppress evidence. That's a motion to suppress. All criminal defendants make it when they feel that evidence is illegally seized or statements are unlawfully obtained. It says move to suppress evidence of, number 1, the drug detection dog's reaction. So, drug dog reaction. I assume it'd start barking. Drug dog reaction means it probably sensed some type of drug. Okay, the small box. And overheard conversation. Conversation. That's overheard. Well, I know that generally if you're making statements recklessly or out loud, you're not trying to keep it private, somebody overhears it, well, that's not a search. That's nothing wrong with that. The police can definitely hear that, depending on where they're at, and that's what this essay ends up dealing with. And they say, under the Fourth Amendment to the United States Constitution, Fourth Amendment deals with search and seizures by the police. Fifth Amendment deals with Miranda and the right to counsel, actually more like Miranda and the privilege against self-incrimination. The Sixth Amendment deals with the right to counsel, all your trial rights, confrontation clause, right to a fair trial, so on and so forth. But now we're specifically focused only on the Fourth Amendment, and this essay only goes through a Fourth Amendment analysis. Okay, let's take it from the top. Now that we know what the call to the question is. Oh, and a police officer had a hunch. Now we know from everything with criminal procedure, a hunch is not enough to create probable cause. It's not even enough probably to get reasonable suspicion to conduct a Terry stop, which would be a pat down of the clothing. That Dora might be selling meth from her house in the country. Notice that it's in the country. That's different than living in the city. For those of you that have ever lived in the country, you realize that houses are very spaced apart, and it's hard to hear things from inside your house. Your neighbors can't hear things. You're in the city, everyone's on top of each other. You hear people walking, you hear people going up the stairs. You can hear their conversations, the windows are open. But when you're in the country, not so much, and that actually plays a critical part in the analysis of the overheard conversation. So if you want to know what separates a great answer from a good answer from a bad answer, a great answer is going to pick up on the little detail and connect the dots to what the examiners are actually trying to say. They don't give descriptive language without a reason, because they could have just said might be selling meth from her house, but they didn't say that. They said might be selling meth from her house in the country, which is your cue to go, how is that going to play a factor into this? It has to do with the conversation. Okay. To learn more, Owen drove to Dora's house with a drug detection dog and waited until she left. So far, he's not done anything wrong. The officer's not done anything wrong. He can sit outside. He can follow her. He can walk the dog around the outskirts of the property, not on the property. But usually what they do is they'll do a stakeout. They'll observe the suspect and see if any crime has been committed, usually undercover. Owen first walked the drug detection dog around Dora's house. At his direction, the dog jumped up on the porch, sniffed the front door, and indicated the presence of methamphetamine. Okay, so the first two paragraphs go to call 1. And you'll notice if you draw a line through it, you'll be able to see how this essay is easily split up. So if you notice, the first two paragraphs go to call 1. The paragraph after that goes to call 2. And essentially the final paragraph goes to call 3. So this is just 3 little mini essays, and you have to discuss each one in turn. So now we might as well talk about the drug dog reaction. What they're actually asking here is, was this a search? Because the Fourth Amendment only protects against unreasonable. That's why the reasonableness of a police conduct will trump the Fourth Amendment, because the Fourth Amendment only protects unreasonable searches and seizures without a warrant. So here is whether or not the officer actually searched her property. And this is where the Supreme Court has said what the definition of a search is. A search can be conducted in one of two ways. The whole issue is whether or not it was a search. Two things can constitute a search: a trespass or a reasonable expectation of privacy. That's when they intrude into a reasonable expectation of privacy. A trespass is when the police physically intrude into a constitutionally protected area. All right, so let's think about what the officer did here. He walked the drug detection dog around Dora's house, had the dog jump up on the porch, sniff the front porch, and indicate the presence of meth. So the dog's essentially sniffing out what's inside the house. So the question is, did the officer physically intrude into the confines of her home? Well, he is within what's called the curtilage of the house. Now, the curtilage of the house is the area immediately surrounding the home. It's kind of tough for people to understand that concept unless you've actually been to the Midwest or a state where properties are pretty vast. If you ever actually drive through the middle America, you'll see that there'll be farms and like a house on acres and acres of property. You don't have to see that in Los Angeles or San Francisco because everything's so condensed. And there's only certain areas that are within the immediacy of the home. The porch is definitely one of them. But when you're talking about the woods and the fields, like when I grew up in my backyard, we had a big backyard. We grew up in the East Coast, northeastern Pennsylvania, and there were woods everywhere in the back. And that would be not considered the curtilage because it's not the area immediately surrounding the home, so there'd be no reasonable expectation of privacy there. All right, but here, by jumping up onto the porch, the dog has invaded the curtilage of the home, and that's a physical intrusion. Now, there's an argument by the prosecution, and this is what was argued in the Florida versus Jardines case in 2013, which is almost what these facts are based on, was that, hey, the officer did what any other person would do. Think about this. If you're a solicitor or if you want to go door to door for whatever reason, you can walk up to someone's house, you knock on the door, and you have the implied consent to do that. You're not a trespasser unless they ask you not to come on their property with a sign or whatnot. But you knock on their door and somebody can invite you in or they can ask you to leave. So that's kind of the implied consent, to go up to the door to knock and see if anyone's home. Well, the officer is it's called the implied consent doctrine. And this is a really small part of the issue, but it has to do with the trespass and whether or not what the officer did was constitutional. But the implied consent doctrine only goes so far. You can only do what a normal person would do. If you were to go to someone's house, knock on the door, and they're not home, you're not going to look around the house, you're not going to search the inside of the property, and that's exactly what the officer did. So he actually exceeded the scope of the consent by using a drug-sniffing dog and drug dogs, because you have to talk about the drug dog. It's kind of like using sensor-enhancing technology because that's something that's not available to the general public use, and the dog is actually sniffing the confines of the inside of the house. Keep in mind, you can use drug dogs in public, so they can walk a dog around your car during a traffic stop, your luggage at the airport, but this has gone too far. It's within the curtilage of the home. It's a physical intrusion. The officer has exceeded the scope of his consent by having the dog jump on the porch, and the average person wouldn't consent to that, so there was no invitation for the officer to do that. Therefore, it actually is a trespass. Pretty interesting analysis of a search. That's how it goes. For reasonable expectation of privacy, of course you have reasonable expectation of privacy in your home. It's a very intimate area. And that one was the easy one. The trespass one was the one where they really wanted the analysis to get in there. They were looking for curtilage, the physical intrusion, and how the drug dog, while that's not generally in the public use. Okay. Moving on to the second paragraph. That was the entire call one. It was by far the most important call here. Number 2. So when Owen then propped the ladder on the back of the house, climbed to the top, and peered into a second-story bedroom window. Now, officers are allowed to view anything, just like the general public, from a lawful vantage point. If you want to rent an apartment across the street from somebody, use binoculars to look into their living room, totally fine. There's nothing wrong with that. But what you can't do is what the officer did. I mean, we do have a reasonable expectation of privacy to believe that the government's not going to be lurking right there in our window. I mean, could you imagine living in the country where you're not going to get a lot of visitors, definitely not a lot of foot traffic out in the country, and all of a sudden you have an officer on the second story of your bedroom window, like peeping in like a creeper. So that would be, that's definitely a search. Even though we used binoculars, I don't know if we got to that point yet. Let's see. He propped the ladder in the back house, climbed to the top, and peered into the second story window. He saw a small box on a bedside table, but could not read the label. He used binoculars to read the label and saw that it listed ingredients that could be used to make meth. Okay, so the first part is whether or not propping the ladder up in the back of the house. And that is a search because the officer hasn't physically intruded into an area where people expect privacy. And definitely the second story window is a place you expect privacy from a ladder being propped up against it, but not if somebody saw you from a distance from their own house. So that goes in whether or not there was a search, whether or not it was in plain view. Because the plain view requires lawful vantage point. And it has to be immediately apparent. Very heavily tested exception on the bar exam and all the way. So plain view, was the officer in a place where he had the right to be? The answer is clearly no. He's physically intruded into an area which we expect to be private. It's very intimate, looking into a bedroom and a second story window. There's not much more Dora could have done to maintain her privacy, and she does have a reasonable expectation of privacy because the officer was not where he was allowed to be. It violates the plain view doctrine. And even if you said the officer was in a lawful vantage point, let's say he did it from across the street or from a neighbor's house, nevertheless, the items were not immediately apparent. A lot of people didn't catch that. Notice what it says. He sees a small box, and all it had was the ingredients used to make meth. I mean, you could have been writing down something you saw on a TV program. You don't know what's actually in the box, so there's no probable cause there to even get a warrant, because there has to be more facts. But anyways, it wasn't immediately apparent what's in the box. All we see is writing on the outside of the box. You can't detect what's in there, and a lot of people miss that. So the binoculars are fine because the binoculars are general circulation. Everybody can use binoculars, so therefore the police can use them. But it violates the plain view doctrine because the officer was not from a lawful vantage point, and it definitely wasn't immediately apparent whether or not there were drugs in there. Even assuming there was probable cause, let's say the officer saw drugs inside the house. Would that entitle the officer to go into the home and seize the drugs because they're in plain view? The answer is no. You actually cannot go into someone's house without a warrant. The Supreme Court is very big on that. Anytime the officer enters a home, there can only be three ways an officer can enter the home. Number one, consent. Number two, an emergency. And number three, if you have a warrant. Other than that, officer cannot enter your house, not under any other exception. That's an interesting point that's often overlooked. Okay, so number three. Owen went back to his car, saw Dora return home, and then walked back to the house and crouched under an open window. He soon overheard Dora telling a telephone caller, "I can sell you several ounces of methamphetamines." Okay, so here's the overheard conversation. Question is, does she have a reasonable expectation of privacy in it? With conversations, there are a few things to consider. Number one, there's wiretapping. And in order for them to tap your phone, they need a warrant. And that's been it's really hard to get a wiretap on your phone. So if you think anyone's listening to your calls, it is very minimal chance the government is actually listening to your calls. It is really, really hard to get a wiretap. Anyways, there was no wiretap here, but he was not using that. He's actually observing it from his own ear. It's called plain hear. There's plain view, plain touch, and plain hear. So by overhearing the conversation, he's not using anything to help him, no wiretapping. Now, the question is that going to be fine? And she's talking to a third party. You have no reasonable expectation of privacy in the person you're talking to. because they might betray you. It's also what's called a false friend. So let's say I tell you a secret. I tell you that, hey, I killed somebody, and I have no reasonable expectation of privacy that you're going to keep that a secret. Also, so that's what's called a false friend. You could also be wearing a wire. And if you are wearing a wire, that's totally constitutional. That's the same thing. And most people, oftentimes, undercover agents do wear wires. And you've probably seen many shows or datelines where the officer wears a wire for like hitman or whatever the case is. So wearing a wire. Here's the issues the examiners were looking for here. So the government's going to analogize the overheard conversation with the false friend out and go, hey, it's the same thing as the person on the other line actually speaking to the officer and betraying Dora's confidence. One thing that's really so overhearing conversation is fine. The question is, did the officer have a right to be there? And he is crouching under an open window. And we have to assume that the government's not lurking in front of our houses, crouching under open windows while we're having phone conversations. So did Dora try to keep her conversation private? I mean, she was in the confines of her home. She was speaking with the window open. But I think we have a reasonable expectation of privacy that people in the country aren't going to be able to hear your conversations. So for number 3, that's actually a really close call. Here, it's definitely a search. It's definitely invalid because no exception applies. Again, small box, when he propped the ladder up in the window, it's not in plain view. And for the overheard conversation, you could go either way on the analysis with that. I just want to make sure I wrap up, make sure I didn't miss anything. Oh yeah, and so because of the unconstitutional search, the exclusionary rule will bar evidence of the drug dog's reaction, and the fruit of the poisonous tree doctrine, anything that derives from that is fruit of the poisonous tree. So the officer's not going to be able to claim that the dog's reaction gave me probable cause to be where I was, and therefore I didn't violate any of your Fourth Amendment rights. That argument will fail because this is all fruit of the poisonous tree because it all stemmed from the drug dog's reaction. Don't forget, the officer only had a mere hunch in the beginning. Now, this essay was not easy, so don't beat yourself up if you had a hard time with it. This was definitely a difficult criminal procedure essay, but that's it. That's a wrap. It goes to the Fourth Amendment and deals mainly with searches.